Texas wage theft, first steps after your paycheck is stolen. No state DOL. What to do? Texas is the only state in the U.S. without a state Department of Labor. That means there is no state agency where you can simply file a wage claim. If your employer stole your paycheck, you cannot call a Texas labor board. But you still have powerful federal rights under the Fair Labor Standards Act of 1938, enforced by the U.S. Department of Labor's Wage and Hour Division. As stated on the official website of the U.S. Department of Labor at dol.gov, the Wage and Hour Division investigates violations and recovers back wages for workers across the country, including Texas. This presentation walks through exactly what to do, step by step, when your Texas paycheck has been stolen. From documenting evidence to filing a federal complaint, hiring a private attorney, and knowing your retaliation rights, you do have options, even without a Texas DOL. Why Texas has no state DOL, and what that means for you. Texas is unique. It is the only state in the United States that does not have a state-level Department of Labor agency. While states like California have the DLSE and New York has the NYDOL to handle wage claims, Texas relies entirely on federal enforcement. The Texas Workforce Commission at wc.texas.gov administers unemployment benefits and workforce programs, but does not accept or process wage theft complaints from private sector employees. The TWC cannot order your employer to pay stolen wages. Because Texas has no DOL, the primary enforcement agency for wage theft in Texas is the U.S. Department of Labor's Wage and Hour Division. The WHD investigates FLSA violations and can order back wage payments. In fiscal year 2023 alone, the WHD recovered over $230 million in back wages nationwide, including millions for Texas workers. Private lawsuits under the FLSA are the other main avenue. Section 16B of the FLSA gives employees the right to sue their employer directly for unpaid minimum wage, overtime, and liquidated damages equal to the unpaid amount, effectively double damages. The practical takeaway: without a Texas DOL, you must be more proactive. But federal law provides robust remedies, and Texas workers are entitled to the same FLSA protections as workers in any other state. Step 1. Document everything. Build your evidence file now. Before you file any complaint or lawsuit, you need evidence. Wage theft cases are won or lost on the strength of your documentation. Under the FLSA, your employer is required to keep accurate records of your hours and wages, but many Texas employers do not. Your own records can fill that gap. Start a daily log of your start time, end time, and any unpaid breaks every single day. Save all pay stubs, even if they are wrong. Under the FLSA, employers must keep payroll records for at least 3 years. If your employer fails to produce records, the court can rely on your reasonable estimates of hours worked under the burden-shifting standard established by the U.S. Supreme Court in Anderson v. Mount Clemens Pottery Company in 1946. Preserve all communications, emails, text messages, and app messages about scheduling, pay rates, and overtime. Gather supporting documents like W-2 forms, any 1099 forms if you were misclassified, contracts, and employee handbooks, and identify coworkers who experienced similar wage theft. FLSA collective actions require multiple employees who were victims of the same policy. Having coworkers join your case can transform it into a powerful collective action. You can find the full text of the FLSA record-keeping requirements by following the QR code on this slide. Step 2. File a complaint with the U.S. Department of Labor for free. The Wage and Hour Division investigates FLSA violations at no cost to you. You do not need a lawyer. To file, call 1-866-4-US-WAGE. That is 1-866-487-9243. Or visit your local WHD district office in Dallas, Houston, San Antonio, Austin, El Paso, or Fort Worth. You can also file online at dol.gov/agencies/WHD/contact. The process is confidential. The WHD assigns an investigator who will interview you, the employer, and witnesses inspect payroll records and calculate back wages. The investigation typically takes 3 to 9 months. If violations are found, the WHD issues a back wage determination. If the employer pays, the case closes. If the employer refuses, the WHD can sue on your behalf. The statute of limitations for FLSA claims is 2 years for non-willful violations and 3 years for willful violations. File as soon as possible to preserve your rights. And remember, Retaliation is illegal under FLSA Section 15(a)(3). It is a federal violation for your employer to fire, discipline, or threaten you for filing a complaint. If retaliated against, you can recover reinstatement, back pay, and compensatory damages. As stated on the official U.S. Department of Labor website, the WHD has recovered over $230 million in back wages in a single year. The system works, but you must start the process. Step 3. Hire a private attorney or join a collective action lawsuit. You have the right to sue your employer directly in federal court under Section 16(b) of the FLSA. If you win, you can recover unpaid wages plus an equal amount in liquidated damages, effectively double your stolen wages, plus attorney's fees and court costs. Many FLSA attorneys in Texas work on contingency, meaning you pay nothing unless you win. FLSA collective actions are different from class actions. Under the FLSA, other employees must opt in by signing a consent form filed with the court. If other coworkers had the same wage theft experience, they can join your case. The U.S. Supreme Court in Tyson Foods v. Buafacchio in 2016 confirmed that representative evidence can be used in FLSA collective actions, making it easier for workers to prove their case when employer records are incomplete. To find a Texas FLSA attorney, search the Texas Employment Lawyers Association directory at TALA.com or the National Employment Lawyers Association at NELAnews.org. Most offer free initial consultations. Ask about their experience with FLSA collective actions and their fee structure, which is typically 33 to 40% of the recovery. The threat of double damages plus fee shifting makes wage theft cases attractive to experienced plaintiffs' attorneys. Common wage theft scenarios in Texas. Red flags to watch for. Wage theft takes many forms in Texas workplaces. Here are the most common patterns seen by the Department of Labor. First, unpaid overtime. You work over 40 hours in a week, but your paycheck shows straight-time pay for all hours. Under FLSA Section 7, overtime must be paid at 1.5 times your regular rate. This applies regardless of whether you are paid hourly, salary, piece rate, or commission. Second, off-the-clock work. Your employer requires you to arrive early, stay late, or work through lunch without pay. Under the Portal to Portal Act, all hours suffered or permitted to work must be paid. Third, misclassification as independent contractor. Your employer labels you as a 1099 contractor to avoid paying minimum wage, overtime, and payroll taxes. The DOL uses a 6-factor economic realities test to determine if you are actually an employee. The DOL's independent contractor rule, effective March 2024, clarifies this standard. Fourth, salary misclassification. Your employer pays you a salary and claims you are exempt from overtime. The white-collar exemptions require both a salary basis test and a duties test, and the salary threshold is $684 per week as of 2024. Simply paying a salary does not make you exempt. And fifth, illegal deductions. If deductions for uniforms, tools, or cash register shortages bring your pay below minimum wage, they are illegal regardless of what you signed. Retaliation is illegal. Your rights under federal law. Many Texas workers fear that filing a wage complaint will get them fired. Federal law protects you. Under FLSA Section 15(a)(3), it is unlawful for your employer to discharge or discriminate against any employee because they filed a complaint or instituted any proceeding under the FLSA. The U.S. Supreme Court in Caston v. Saint-Gobain Performance Plastics in 2011 held that oral complaints, not just written ones, are protected. If you verbally told your manager you were owed overtime and were fired the next week, you have a retaliation claim. If you prove retaliation, you are entitled to reinstatement or front pay, back pay with interest, compensatory damages for emotional distress in some circuits, and attorney's fees. The WHD can also pursue retaliation claims independently and seek a court order to reinstate you. In addition to the FLSA, other federal statutes protect Texas workers. The National Labor Relations Act Section 7 protects your right to engage in concerted activity about wages, even without a union. This means discussing pay with coworkers and banding together to demand fair wages is protected activity. Texas state law. Texas Labor Code Section 21.055 also prohibits retaliation for opposing discriminatory practices. You have multiple layers of protection. Do not let fear of retaliation stop you from asserting your rights. Federal law versus Texas law. What you need to know about FLSA preemption. When it comes to wage theft, federal law and Texas state law operate side by side. The FLSA establishes a federal floor. States can provide greater protections, but not less. Since Texas does not have a state DOL enforcing stronger protections, the FLSA is the primary shield for Texas workers. The Texas minimum wage is the federal minimum of $7.25 per hour. Texas has no state overtime law beyond the FLSA. Texas has no state meal or rest break requirement. Texas has no state paid sick leave. Texas cities are prohibited by the Texas Local Government Code Section 180.004 from setting local minimum wages above the state rate. So the FLSA is your main tool. FLSA overtime under Section 7 is due only after 40 hours in a week, not after 8 hours in a day like in California. The tip credit under FLSA Section 3M allows employers to pay tipped employees as little as $2.13 per hour if tips bring them to at least the minimum wage. The Texas Payday Law, Texas Labor Code Chapter 61, does provide some protections. Employers must designate regular paydays and pay final wages within 6 days of discharge or by the next regular payday if you quit. But the Texas Workforce Commission's enforcement is limited. For any wage claim in Texas, the best strategy is almost always to pursue your claim under federal law. The FLSA offers double damages, attorney's fee shifting, collective action procedure, federal court jurisdiction, and free WHD investigation. Texas state law offers none of these advantages. Your action plan, from stolen paycheck to recovery. Start today. If your Texas employer stole your wages, do not wait. Every day you delay, the statute of limitations ticks closer. The FLSA gives you either 2 years for non-willful violations or 3 years for willful violations from the date wages were due. Here is your action plan. Step 1. Stop the bleeding. If you are still working for the employer, continue documenting everything. Do not quit without consulting an attorney. Continue tracking your hours meticulously. Step 2. File with the Wage and Hour Division. Call 1-866-4-US-WAGE or visit dol.gov/agencies/WHD/contact. The WHD investigation is free, confidential, and you do not need a lawyer. Step 3. Find an FLSA attorney. Search the Texas Employment Lawyers Association at Tela.com or the National Employment Lawyers Association at nailanews.org. Most offer free consultations and work on contingency, typically 33 to 40% of the recovery. Step 4. Join or start a collective action. If coworkers had the same experience, an FLSA collective action can recover wages for the whole group with one case. Attorney's fees are paid by the employer if you win. Step 5. Preserve all evidence. Back up your documentation in at least 2 places, cloud storage and a physical copy. Do not store evidence on your work computer. Retaliation for filing a wage complaint is illegal under FLSA Section 15. 3. You are protected. The law is on your side. Start today.